Good afternoon. Thank you all for being so prompt. We're going to start on time, which never happens, so this is a first. I'm Mark Watts. I'm a partner here at Bristow's, and it falls to me just to welcome you all to our second Tech Summit. So we hold these every other year, and really it's an opportunity for us to meet a number of our clients and to take a cross-section of members of the firm to talk about legal and regulatory issues affecting the tech sector, which is why we're here today. Typically, actually, I'm going to divert myself. I'm going to say the thing I mustn't forget. There are no planned fire alarms. So if anything goes off, we'll tell you what to do. If I hadn't said it then, I would have absolutely forgotten. But what I was going to say was the subjects that we talk about are typically informed by the questions crossing our desks from clients. We try and use that as a measure of what people are interested in and what people might want to hear more about. And this has felt like a very regulatory time, I would say. We're getting a lot of questions about a lot of new regulations. And so that's kind of the theme for today, really. There's going to be a lot of regulatory stuff. And it's kind of interesting because for those of you who've been doing technology law for a long time, it may have felt like the tech sector was fairly unregulated and got off lightly compared to, say, banking or the pharmaceutical sector or certain other sectors. We had data protection law, but for a long time, it was important, but there wasn't a lot of enforcement. Maybe there weren't any enforcement powers. It didn't feel like such a big deal. We had competition law, but that tended to touch only the very biggest companies, and somewhat rarely there was a small number of very high-profile cases. And we also had e-commerce legislation, but again, it didn't feel weaponized, or it felt more like something that tech companies could rely on, like the hosting defenses, to get them out of trouble in certain situations. So I'm not saying we haven't had regulation, but it just felt like a very different situation to what we have now, because now it really feels like a lot of things have changed. And we hear a lot of concerns voiced about not just technology, but perhaps big technology, some larger companies, and looking at what's the impact on democracy, what's the impact on privacy, on advertising, how do we on online safety, content, how do we address those issues while at the same time having a vibrant and thriving European or UK economy? How do we get it right? And so here we are with a load of laws coming at us. So in the EU, probably nearly all of you, if not all of you, will have been to lots of talks about the AI Act. Obviously, we also have the Digital Services Act, we have the Digital Markets Act, we have NIS2 on the security side. And then in the UK, of course, now post-Brexit, we have our own way of doing things. So you'll have heard a lot about the Online Safety Act. You'll have heard about the Digital Markets Competition and Consumers Act. So there's a lot coming with big, serious enforcement powers as well. So you're going to hear a lot about regulation today. Bear with us. You're going to hear from a number of the key, or three of the key regulators who are looking after the technology sector. So we're excited to have representatives from the ICO, Ofcom, and the CMA here. But before we get to that, we're going to start with an AI theme, but we're going to try and do something that we're not hearing a lot, we haven't heard so much about, but we think is going to be a very, very big area very soon. And that is the intersection between artificial intelligence and intellectual property. So with that, I will hand you over to my three colleagues over here.
So, my name is Toby Headdon. I am a counsel in Bristow's Brands, Designs and Copyright team. And I'm going to talk to you today about copyright and AI and the intersection between those two disciplines. I thought, on the assumption that not everybody may be intimately familiar with those two things, I'd start with a very, very basic primer as to what they are. So, copyright essentially is it's a legal right that entitles the owner to reproduce and make available to the public copies of their protected works. It's important to note that it covers quite a broad church of things. So literature, text, books, art, graphic works, photographs. It even covers source code and object code for computer programs. So there's a lot of things that it covers. The other thing to bear in mind is that you don't need to create a masterpiece to get copyright. The threshold for protection is relatively low. So essentially, you just need a relatively modest degree of human creativity. And if you can demonstrate that in your work, you're going to attract copyright protection. Just as an example, the sentence there below, understanding copyright, it's plausible that that could be protected by copyright. There was a case in Europe which decided that just 11 words alone were protected by copyright. So you don't need to write a big novel or anything like that. AI, slightly amorphous concepts. There's no agreed consensus, I think, on what it actually is or means, although attempts have been made to define it. I've included one there from the ICO. I think the way I would surmise it is that it's an algorithm-based tech that supplants some form of human thinking. And then, of course, you've got the intersection between these two. And really, what we've seen in the course of the last 2 or 3 years is some critical questions arise within that intersection. So let's have a look at those. I think there's 3 areas, essentially, that I like to think of this as covering. And the first is the use of what we call training data as inputs to train an AI model. So essentially that's saying, okay, you're taking a batch of stuff, which may include copyright works, and you're using it to train an AI model. Does that present any copyright issues? And there's a lot of case law on that at the moment. We'll come to that shortly. The AI models themselves, and the question here is, does the model itself contain a copy of copyright works? And then finally, the output. So what the algorithm or the AI model spits out, and there's some questions around that as to, firstly, whether what it spits out is protected by copyright at all, and if it is, who actually owns the copyright in that work? So they're the 3 critical questions, and we'll come on to each of them individually. But before we do, I just wanted to cover a few preliminary points. So there's been a bit of debate around the nature of the use of material to train AI models and whether that is actually the type of use that a copyright owner ought to be entitled to authorise, predominantly because what you're doing is not really consuming it or enjoying it in the way that you would if you bought a copy of a book and read it. You're just using it like data. But I think there's an even more important question that's emerging in practice than that, and that is the extent to which this practice of using copyright works to train AI models is actually covered by any copyright exceptions. And again, we'll come on to those in a moment. But the upshot of all of this is that there is a market there, and right owners are seeing this as an opportunity to license their material to AI developers in order to create an additional revenue stream. The licensing deals are already happening in the market. So it's been reported that OpenAI have entered into deals with Associated Press, Axel Springer, Le Monde, the FT, Reddit, Condé Nast and Shutterstock, among others. So this is a market that's evolving and developing, even though there is also litigation on foot, again we'll come to that in a moment, which is calling into question the principles that should apply. I suppose the final point to make as a preliminary point is that we can't really look at these as silos or individual buckets. There's a degree of interrelation between them. So just by way of example, if a bunch of works from a particular artist are used at the input stage, and then someone at the output stage, a user, goes to the AI model, types in a series of prompts to say, please produce a painting in the style of said artist. You can see that that means that they can produce works which are in the style of that artist and effectively cannibalize the market at the output stage. And that arises by dint of what's used at the input stage. So there is a degree of interrelation between those, and they can't really be viewed, I think, in silos. Right, so the first question we touched on was the input question, and this is really, does the use of copyright-protected material to train an AI model infringe copyright? The first point to bear in mind about this is copyright is territorial, and by that I mean that each country has its own copyright law. So whether there is an infringement of copyright will depend upon which law applies, and that will depend upon where the training takes place. Now, at the moment, there are a lot of cases on foot in the States. So many of the large AI businesses there are being sued. I think there's causes of action against Microsoft, OpenAI, Meta, NVIDIA, Anthropic, Stability AI, Midjourney, to name a few. So that is where the centre of gravity of these disputes is taking place, and that really reflects the fact that so much of the business is located there. There is one case before the UK courts at the moment, that's Stability AI and Getty, although that's not got very far along at the moment, but we keep a close eye on that. Now, I mentioned copyright exceptions before, and that being a question that's sort of come to prevalence. So in a lot of these cases, in the US, one question which has been advanced by the AI developers is that, look, what we're doing is merely a fair use of the material, and therefore we don't require the permission of the copyright owner to do it. So this is a general doctrine which in certain circumstances permits businesses, entities, people to use copyright material without having to get a license and pay for it to do it. It's quite a fluid doctrine. It's very fact specific, so it's always difficult to make a determination and say, yes, that is clearly a fair use, or no, that is not. So I suspect what we'll see in these cases in the US emerging is different decisions, some of which may be fair use, others of which may not. But hopefully we can pull the threads together from those cases and try and work out what the parameters are. It is an open question, this litigation. I think in the UK, we have a very narrow bunch of copyright exceptions. They're very narrowly circumscribed. There is one which covers text and data analysis for non-commercial research. You can probably see in the words non-commercial. That's very narrow, and it tends not to apply to an entity engaged in a commercial exercise or any commercial endeavour. There have been moves afoot to try and introduce a much broader exception. Unfortunately, these have fallen flat. There was also a move to try and get the industry, both the right holders and the developers together to sort of come up with a code of practice. That has also failed. So at the moment in the UK, we're waiting for the government to make its next move, and there's rumours afoot that there may be an announcement on that towards the end of this year, but we'll just have to wait and see. In the EU, there are two exceptions which cover text and data mining. One is for scientific research, and the other is a general one which applies to TDM for any purpose. The second one is something which a copyright holder can say, well, I don't want my works to be mined by you, so they have a right to opt out of that, essentially. There's a different question as to how you do that, and we'll come on to that right now, because there's been a case towards the back end of last month in Germany at the Regional Court of Hamburg, and this was a case where a court rejected a photographer's claim that Lion, which some of you may be familiar with, offers data sets for use in training AI models, that they'd used one of his photographs in the training data set. And he said, well, you can't do that, that's an infringement. Now, the court found that the EU TDM exception for scientific research applied to Lion, and therefore they were entitled to use it and didn't require a license from him. There are some questions around that decision as to whether, for example, it didn't properly take into account the fact that Lion not only used this in order to train the model, but they also then made the model available to third parties who did use it on a commercial basis. But the court confined itself to a much more restrictive analysis. So there's some questions around just how far that decision goes. What was interesting about that case is that they also said, well, we're not going to make a decision on the general purpose one, which has the opt-out provision, but we think that probably, they didn't make a firm decision, but they said probably it is the case that you can opt out by simply using plain text in your terms and conditions, provided that the machine, the algorithm that's sent to collect and harvest that data, can read that and recognize it and understand it. So that was quite an interesting point, because there have been some question marks around that. So there is legal risk. Of course, there's enforcement risk as well, which is always a separate and more practical element. Is there a risk of enforcement? Well, at the moment, the first wave of litigation seems to be against all of the big AI developers, and that's not surprising, and most of it's happening in the US. But once that first wave has passed, it's quite plausible that the targets will open up, and more businesses, perhaps smaller businesses, will start to find themselves subject to lawsuits. There are also transparency obligations afoot, where there are moves in the UK and within the EU to try and encourage companies to be more transparent about the data that they're using to train their models, so that, for example, a copyright owner can look at a data set and say, my work's in that one, so I know you must have used it, so I can opt out or I can take action against you if I'm not happy about it. Right, so that moves us on to the next issue, which is, do the AI models themselves contain copies of the copyright works? Well, the answer to this is quite simple, no, they don't. So if you look under the hood, the AI model is not a database. So it's not like a database which has got copies of works and you type in a prompt and then it selects that copy and churns it out in a slightly different form. It's a series of weights and parameters. But without going into the technical side of things, there is a case in the US at the moment. It's a case brought by the New York Times against Microsoft and OpenAI, where the New York Times alleges that OpenAI's GPT models have actually memorized the New York Times copyright works. Now, the concept of memorization is slightly unclear, I would say, at the moment. There's no real consensus on what it actually is, whether it's actually occurring in these AI models, and if it is, what the copyright consequences actually are. Some academics have suggested, well, look, if the model can effectively reconstruct a copyright work in near exact form, then memorization must have occurred in respect of that material. So I guess that begs the question, you know, how do we really explain it? Well, it's often been referred to as the Snoopy problem. And that's really because if you or me or anyone goes to an AI model and types in, you know, produce a picture of the Snoopy cartoon character, the chances are it's going to produce a picture which is very close to the Snoopy cartoon character. And why is that? Well, because even though the model isn't a database which contains copies of those works, it's memorized them. So there is something in this argument. It's just that the parameters haven't really been firmly set yet. And it may well be that at this New York Times and OpenAI case, we get some answers on that point. Next slide. Okay, so we're on to the sort of third tranche, if you like, and there's two bits to this. So can copyright subsist in an output generated by an AI rather than a human? Generally speaking, again, this is there's some slightly different approaches taken between different countries. Generally speaking, in the US, the position is you have to have a human input. So the Copyright Office there has issued various guidance saying human authorship is required. That does not mean that you are not allowed to use AI, but you have to make sure that if you do, that there's a human involved as well. And it's the human, the creative element of the work must be inputted by the human rather than the machine or the model. In China, the Beijing Internet Court last year looked at a work generated by Stable Diffusion, the image diffusion model, and concluded that it was protected by copyright because it reflected the creative choices of the person who'd entered the prompts to actually elicit the image and then fine-tuned it afterwards. So not a markedly different approach to the US, but you can see that it's certainly more AI friendly. I'm going to touch briefly on section 9.3 of the UK's Copyright Act. This was introduced back in 1988, so over 36 years ago. And it's an odd provision, so it essentially talks about computer-generated works. And this is defined as a work with no human author. That's an important point, remember that. And essentially it says the author of a computer-generated work is the person who made the arrangements necessary for its creation. So on the face of it, that looks as if it's an amazingly prophetic provision that, you know, could cover an AI-developed work. Possibly, but I think there's a problem, and I think lots of people recognise that this is a problem. And the problem is this: under EU law, which has evolved and is still applicable in the UK post-Brexit, a fundamental element of copyright protection is that there is human creativity. So you have to have human creativity. If a computer-generated work has no human author, there could be no human creativity. That's a tension which has not yet been resolved in any court decisions. So it's a sort of an unknown, if you like. I think as a practical tip, the best policy at the moment is to make sure, if you are looking to get copyright protection in an output, to make sure that a human has had some significant creative input in that, whether that's through the prompts or otherwise. But that in itself is quite a complex question. It's not one that I propose to answer here, but it raises probably more issues than it answers. The secondary question, if there is copyright that subsists in a computer-generated work, who owns the outputs? Who owns the copyright in those outputs? Again, copyright's territorial, so it will depend upon the country where the activity has taken place, and that law will apply. But you have to ask yourself, what's the extent of the human contribution? A bit like, they did in China, in the Beijing Internet Court in that decision. You have to ask yourself, what's the role of the AI model, and possibly who is responsible for that, and put all of those things in the mix. And then you also have to ask yourself, well, actually, do the AI model developers' terms of use say anything about ownership? Like, if you use our model and you produce something, we own the rights. Now, at the very beginning, about 2 years ago, OpenAI's terms of use said exactly that. They changed it very quickly because they didn't want the hassle and the sort of potential liability. But if you put all those factors into the pot, the possibilities are really basically as follows: that it might be the creators of the AI model that own the copyright. It could be the user. That's typically the most common under terms of use of AI model developers. They push ownership of copyright onto the user or IP. It could be a combination of both if they both had input, or it might be no one. For example, if the terms of use say, look, any outputs are in the public domain, or if there just is not sufficient human input to merit having copyright, then it might be no one. So ownership, we touched on this, it's an important issue because if you own the copyright, that entitles you to commercially exploit it, and that's what people are obviously interested in. You want to be able to commercially exploit those outputs. Again, commercial exploitation of outputs may be subject to terms of use of the AI model developer. So there's another point to think about there. There is also a risk that any commercial exploitation of an output might infringe copyright in a work which was used at the input stage as well. So that may be a limitation or something to think about if you are looking to use an output, particularly if it reproduces the whole or substantial part of a copyright work which is used at the input stage. And then on top of all of that, you have to ask the question, well, if that's the case, who's the infringer? And again, that's another thorny question, and I don't propose to go into that today. Look, that's what I wanted to say on copyright and AI. Thank you for listening. I'm now going to hand over to Naomi and Eden, who are going to say a few words to you on AI and patents.
So I'm Naomi Hazenberg. I'm a partner in the patent litigation team, and I'm joined by Eden. And like Toby, we're going to start with a very, very brief primer on what a patent is. So we're sure you already know, but a patent grants an exclusive right to an invention for a limited period of time, typically 20 years, and that allows the patent owner to control how their invention is used. It protects them, therefore, from unauthorized exploitation of their invention. This system is designed to promote innovation. But when we talk about AI inventions, what do we mean? We mean AI-generated inventions and also inventions that utilize AI. The various categories of what could be coined AI inventions are shown in this figure. And the more sophisticated technologies are sitting towards the center of the circle. The easiest way to think about these categories are that on the outside, we have the things that are hard for humans, but easy for computers. So applying predetermined rules to large data sets. But the AI technologies towards the center of the circles, such as representation learning and deep learning, are useful for things that are easy for humans, but hard for computers. So for example, pattern recognition, image processing, or natural language processing. It's primarily the AI technologies towards the center, and in particular deep learning and neural networks, that have come up in patent cases in recent years. And so our focus is going to be on those today. These technologies continue to gain significant recognition for the advances they deliver. For example, the recent Nobel Prize in Chemistry that has been awarded to Google DeepMind for their tool predicting protein structures.
So what are the critical questions? Much like Toby outlined in relation to copyright, the intersection between AI and patent law also raises some interesting issues. Again, many of these questions are the subject of current legal cases, and so the principles aren't yet settled. On the topic of inventorship, our traditional patent frameworks were designed to protect human-made inventions, and with AI systems autonomously or semi-autonomously developing solutions now, the legal boundaries here start to become a little bit blurred. Current laws don't fully account for AI systems as inventors, raising questions about who should be credited for the invention, whether it's the AI developer, the AI itself, or the user who utilizes the AI. Tied up with this are issues of ownership. If AI is involved, questions arise about who holds those ownership rights. Should it be the individual company that uses the AI, the developer of the AI, or should we have some form of shared ownership?
The other aspects that have arisen in terms of patent law questions focus on the actual patentability of the invention, and this also remains unclear when it comes to AI inventions. The traditional patent frameworks have created criteria for inventorship, novelty, non-obviousness, and sufficiency. However, some of those definitions become really strained when you put them in front of an AI-generated invention versus a human contribution. The resulted ambiguities have created uncertainty as to when, or even whether, an invention that's created by an AI could qualify for patent protection under the existing legal structures. As a result, patent offices around the world have been grappling with how to evolve in response to the rapidly developing AI technologies.
So for the first part of this discussion, it's helpful for us to set out what we mean by an AI-generated invention and give you an example. So here we mean that the core of the invention or the inventive concept has arguably been conceived by the AI system. And a prime example of this is in the field of drug discovery and AI-identified molecules, because AI systems can analyze vast databases and identify new structures that could serve as potential drugs. So one example is in 2020, an AI system identified a drug molecule for OCD, which then advanced to human clinical trials. And this helped identify the compound far more efficiently than traditional drug discovery methods. Typically, it takes around 5 years for a drug to reach clinical trials, but here the AI drug reached trials in just 12 months.
So rather than walking you through the legal updates by themselves, we thought we could pick up the key points by setting out a realistic fact scenario that might crop up in a company that uses AI to work on complex problems. So, in our scenario, we've got an automotive company, Auto Innovate, and they've developed a highly advanced AI system called DesignBot to assist its engineering team in creating innovative, energy-efficient vehicle components. DesignBot has been trained on vast data sets of material science, aerodynamic simulations, and historical vehicle designs. Its purpose is to suggest new design configurations that optimize energy use, reduce weight, and improve durability.
So the first issue we'll look at in this scenario is patent eligibility or excluded subject matter. So in our fact scenario, let's say that one day, while tasked with improving the efficiency of electric vehicle motors, an engineer uses DesignBot to generate a completely new cooling system. DesignBot comes up with a heat dissipation design that uses a combination of advanced materials and a unique pattern of airflow channels. So can this invention be patented? And what about patenting DesignBot itself?
So the excluded subject matter principles in English law define the boundaries about what can be patented and what can't. Similar exclusions generally apply around the world. These exclusions are based on certain subject matters where, as a matter of public policy or practicality, the subject matter isn't considered as an invention for the purpose of patent protection. These include scientific theories, aesthetic creations where you'll need to call on Toby for your design and copyright protection, and programs for computers. These exclusions prevents patents from being granted for contributions that lie solely within the excluded subject matter, unless there's a technical contribution beyond that exclusion. So, for the new heat dissipation design, we're unlikely to fall within those exclusions, as far as eligibility is concerned, this should be patentable just like any other mechanical invention.
But regarding DesignBot itself, the situation is a little bit trickier, and it depends primarily on how the invention is framed. The relevant exclusion here is likely to be the exclusion for computer programs. A recent case in the English Court of Appeal considered this exclusion in the context of AI systems, in particular in the context of neural networks. The Court of Appeal ruled that a music recommendation tool that used a neural network should be treated the same as any other computer program under patent law. This overturned the High Court's decision. In essence, the decision stated that a neural network-based process is basically still a set of instructions for a computer to do something, and therefore it is a computer program. And as I said, in doing so, they dismissed the High Court's finding because the High Court had found that unique features of neural networks differentiate them enough to move them outside of this default ban on patents for computer programs. So after finding that this tool was in fact a computer program, they then turned to whether it was nevertheless patentable by virtue of making a technical contribution beyond just being a computer program. They found that this assessment wasn't impacted by these unique features of a neural network either, and it was instead determined by the function or the output of the model. So in order for DesignBot itself to be patentable, you need to think about this technical contribution test and how you can pass it. You have to claim a technical effect beyond just the internal workings of DesignBot. So you might do this through seeking protection for the use of the AI system for a specific technical purpose. For example, in this case, claiming the creation of designs of energy-efficient vehicle components.
So, moving on with our fact scenario, let's say you're working in Auto Innovate's patent department. You've been told by us that you can patent the motor cooling system, but you do know that you're going to have to set out who the inventor is and who the owner is when you're filling out the form. But whilst the engineer prompted DesignBot, they hadn't previously considered this cooling system, and it was entirely generated by AI during its autonomous design process. What are you going to do?
So these questions have already been raised around the world in what are referred to as the DABUS cases. DABUS is an AI system created by Dr. Stephen Thaler, designed to generate ideas without human input. Dr. Thaler claimed that DABUS generated 2 inventions without any direct human involvement, and he sought to patent these inventions. He named DABUS as the inventor, while listed himself as the owner of the inventions. And the central legal issue in these cases was whether an AI system could be legally recognised as an inventor on patent applications.
The UK rejected these applications, and that was generally a consistent outcome across the world. Various patent offices reached the same conclusions, including the US PTO and also in the EU. The case has sparked debate about whether patent laws need to be updated to accommodate AI-generated inventions. But looking specifically at the UK decision, what the court did was look at the scope and meaning of the term inventor in the statute and whether that could be extended to cover a machine. The court took a very literal approach when taking the statutory interpretation task and found that the inventor had to be a natural person. Similar reasoning was followed in Europe, and as a result of that DABUS case, the latest version of the EPO guidelines state that in every patent application, the inventor has to be designated as a person with legal capacity.
Then on the second issue of whether Thaler could nevertheless own any invention made by DABUS, the court also found against him. And the court held that ownership of the machine wasn't included in the exhaustive list of scenarios where a person is entitled to a patent, a person or a company is entitled to a patent, but they're not the inventor themselves. So a classic example of this is as the employer of an inventor, if the invention was created during the course of their employment. And they also held that because an invention is not tangible property, title cannot automatically pass to the owner of the machine that created it.
So, what might you do in this application? Based on current practices and workarounds, you could just think of the AI as a tool. Even if it was the AI that crystallized the invented concept, you could still take this route. In this case, what you might do is say that the inventor of the cooling system was the engineer that used or prompted DesignBot to come up with the design.
Another approach is that the inventor is the person who made the arrangements necessary for the creation of the invention. This is similar to the approaches that Toby was outlining in relation to copyright, in which case the inventor of DesignBot would likely be the software programmers that created it. And in the case of the cooling system, we might be looking at a sort of joint ownership scenario, inventorship scenario, including both the engineer and the software programmers. This primarily depends on what the engineer had to supply for the formation of this invention, for example, particular prompting to get that inventive concept.
But looking to the future, what might happen? These decisions are based on the formal requirements in a statute that was drafted in 1977. Is that legislation really suitable for the modern day? Everybody wants to be a leader in AI, so is reform overdue? One option is to relax the interpretation of the concept of an inventor, so you take a less formal approach and you don't limit it to being a natural person. Alternatively, you could just abolish the formal requirement to say who your inventor is on the application form.
A far more radical approach would be to actually update patent law to recognise AI inventors. And something along these lines has been suggested in a proposed bill in Brazil. But doing so in the UK would also require a rethink of the chain of title.
So now we're going to turn to some considerations relating to inventions that utilise AI. Here, what we mean is that the AI is a crucial part of the solution, but didn't arguably conceive of the core inventive concept. And these often come up in relation to diagnostic tools, where the AI can utilise large sets of medical images and patient data to diagnose and identify diseases earlier and more accurately than existing methods. One example of this was Zebra Medical Vision's algorithms that identified medical conditions such as liver disease and osteoporosis by scanning radiological images.
So the next issue we'll look at is the issue of sufficiency of disclosure in a patent or a patent application. And developing our fact scenario a little more, let's say that following the success of the new cooling system, Auto Innovate invests its profits in developing a new AI system called Speedbot. And this is to be incorporated into car control systems. Speedbot greatly improves cruise control in cars, altering the otherwise fixed speed slightly in response to external factors, such as the presence of other vehicles. Speedbot utilizes a neural network, which is trained on a complex data set comprising thousands of hours of dashcam footage, auto-innovates its own portfolio of car designs, and historical macro traffic data. So in order to patent Speedbot, what needs to be disclosed in the patent application, and do you need to disclose the training data that was used?
So as Eden said, these relate to the sufficiency requirements when it comes to patents, and these stem from the fundamental patent bargain, which is a trade-off between inventors and society and really lives at the core of a patent system. On the inventor's side, in exchange for telling all the details of your invention to the public, what you get is that temporary monopoly, the exclusive right to control how your invention is used for 20 years. On society's side, you get the benefit of the disclosure. That might otherwise have remained secret and encourages innovation where people can build upon the existing knowledge once the patent expires. So that balancing bargain incentivizes innovation and promotes public access to technological advances.
Whilst the precise wording differs by jurisdiction, in light of that fundamental patent bargain, around the world it's a requirement that a patent discloses an invention in a way which is complete enough for it to be carried out or replicated by a person skilled in the art. And inventions using AI harbour particular issues for this sufficiency requirement on a practical level, particularly when using neural networks. If you were to ask someone working in the AI field what information they needed to replicate an invention using a neural network, they'd probably tell you that the basic structure of that AI model isn't enough. They'd likely need reference to some training data or perhaps examples, or they'd need to know every learned coefficient and weight of the model.
The importance of what Eden said just really can't be overstated, as the only parts of the structure in a deep learning model that are predetermined are the input at the beginning and the output at the end. All the layers in between those are called hidden layers, and even once the system is fully trained and operational, it's normally impossible to know exactly what occurs within those layers and how the neural network is approaching the problem. So when it comes to sufficiency, the question is whether a description of the data suffices. So for example, saying tens of thousands of pictures of cars or tens of thousands of pictures of pedestrians, or whether the actual training data itself has to be made available to the public. Providing the training data itself obviously creates problems. It's normally enormous, so that won't make patent applications any smaller. But also, it's highly commercially sensitive. Developers are going to have invested a lot of time and money in gathering and organising that data.
European case law gives us some helpful insight into the sufficiency requirement. There was one invention that used a peripheral blood pressure curve, which is blood in your extremities, such as your fingertips and toes, to estimate an equivalent aortic pressure, so pressure in your heart. And the weighting values used in that estimation were calculated with the help of a neural network. The patent application mentioned that the training data would need to cover patients of different ages, different sexes, and different health conditions to avoid any specialization of the network. But it gave no further detail beyond that, and it gave no examples of training data. And this wasn't enough. So on appeal, it was found that with no disclosure of more specific training data, the skilled person wouldn't be able to carry out the training of the neural network that would be required to replicate the invention. So the application didn't meet the requirement of sufficiency.
So often a lot of value of the invention actually lies in the training data set. So prospective patentees might prefer to rely on trade secret protection, as once the data is in the application, there's no safeguards to protect their training data. In our example, part of the training data includes auto-innovates portfolio of car designs. Therefore, you might need to disclose this data to reach the sufficiency requirements. But given this is obviously highly commercially sensitive, they might prefer to keep this information confidential and fall back on trade secrets. So that was our whistle-stop tour through where the intersection of AI and patents. On this slide, we've just boiled down everything into the key current principles. It's clearly an area where there are currently more questions than answers, and one that's ripe for development and reform.